A Bollywood actor, 27 defendants. One pivotal question. In the age of artificial intelligence and deepfakes, who actually owns your face? Today we are breaking down the Shilpa Shetty case, a landmark intellectual property battle that exposes massive gaps in how Indian law protects identity in the digital age. And trust me, the implications go way beyond Bollywood. Here is what happened. Shilpa Shetty filed a petition in the Bombay High Court against 27 defendants, including Meta, Google, X, Mayet and the Department of Telecommunications, alleging unauthorized commercial exploitation of her name, image, voice, and likeness. The defendants were using artificial intelligence tools, deepfakes, and digital manipulation to create counterfeit content. Videos, morphed images, artificial intelligence cloned voices, all monetized without her consent. We are talking about fake merchandise, deceptive promotional campaigns, and even fabricated social media content. Now here is where this gets legally interesting. India has no dedicated statute for personality rights. None. This means Shilpa Shetty had to cobble together protection from multiple legal frameworks. And therein lies the problem. First, there is Article 21 of the Constitution, the right to privacy and personal liberty. The Supreme Court expanded this in the K.S. Puttaswamy case to include control over one's identity as a fundamental right. That is the dignity angle. Second, there is passing off doctrine and tort law. The courts recognize personality rights as a form of intellectual property, an economic right where your image has commercial value. When someone exploits it without consent, they are essentially stealing your brand. Third, there is copyright and performers' rights, protecting artistic expression. And trademark principles, your name and likeness, can function like a brand. But here is the issue. All these doctrines were designed for different purposes. You are stitching together constitutional law, intellectual property law, and tort law to protect something that arguably deserves its own statutory framework. The timing of this case is crucial. Technology has moved exponentially faster than law. Voice cloning, deepfake videos, artificial intelligence avatars. You can now recreate someone's entire persona with a few thousand rupees and a decent graphics processor. The law has not caught up. And it is not just about commercial exploitation. It is about reputation laundering. You could be used to endorse fraudulent products, promote hate, spread misinformation, all while your face stays pristine online. When courts like the Delhi High Court grilled defendants in the Anil Kapoor and Jackie Shroff cases, they had to stretch existing frameworks, right to information, satire exceptions, fair use, to try and distinguish legitimate commentary from unauthorized exploitation. It is a legal Jenga tower. Here is what keeps intellectual property practitioners up at night. The court, in granting relief to celebrities, has acknowledged 3 layers of protection needed. First, the economic right, stopping unauthorized commercial use. Shilpa Shetty deserves compensation for lost licensing opportunities. Second, the moral right, the right to control how your identity is used, especially in ways that degrade or defame you. Third, the dignity right, protecting fundamental autonomy over your own image. But without statutory codification, each of these remains fragmented across case law. Startups do not know where the line is. Platforms claim they cannot moderate. And celebrities have to litigate their way to clarity. What does this mean for you? Whether you are a policymaker drafting digital rights law, an intellectual property counsel advising creators, or a platform compliance officer, the message is clear. Statutory codification is urgent. We need a dedicated personality rights law that balances 3 things: protection for individuals, breathing room for fair speech and satire, and clarity for digital commerce. Until then, cases like Shilpa Shetty's will keep chipping away at that balance in court. What do you think should be protected? Just commercial use or all unauthorized use? Drop your take in the comments. And if you are tracking intellectual property and regulatory shifts in India, hit subscribe. Thanks for watching.